indicators. Things like domestic violence, child abuse, elder abuse, sexual abuse, neglect, and psychological abuse are all situations that doctors may face. So it's quite proper. Like for instance, when they mention this doctor-patient confidentiality, there are some instances where a patient comes to the hospital with their guardian or with their parent. Let's say, a female patient comes in with perhaps a guardian or the father or the mother, and then you need to get proper information from this patient. It's in your right to ask the guardian or let's say the parent to excuse the room while you get information from this patient. And it's also the patient's right that once you get those information from the patient, you should keep it between you and the patient, except it's something that will need you to escalate. Then you escalate to a senior colleague, which may help escalate to the right authorities. So, patient-doctor confidentiality is something that must be treated with care, because that may be the bridge between violence prevention and victim protection. Now, some findings as well, like multiple unexplained injuries, using
When did I say that
bruises
it's
in
going to
varying
end?
stages of healing, injuries that don't match the history that is given, or signs of fear or withdrawal, or perhaps a delayed presentation to the hospital may be a cause for concern. So these are things that you ask yourself, why is this patient not really giving out information? Is it because of the environment? And then obviously when you ask them, are you comfortable here? They will always say yes, because come on, they don't want the dad or the mom or the guardian to hear what they're about to say, or suspect that maybe that they have something that they're hiding. Now, suspicious injury patterns may indicate non-accidental trauma, particularly in children. And in addition to treating the wounds, the doctor's job is to safeguard the patient who is at risk by ensuring that the patient receives additional help, correctly documenting their findings, following safeguarding protocols, and involving the appropriate authorities when needed. Since many of these patients also have emotional trauma, this area of medicine necessitates both clinical expertise and compassion. The doctor also serves as an expert witness and advisor to the justice system. The direct assistance to the legal system is another significant role that a doctor plays. In order to provide judges and attorneys with an understandable explanation of medical results, doctors may be called as expert witnesses in courtrooms. And this could entail describing the extent of the injuries, potential cause of death, mental capacity, level of disability, or whether the results match reported events. So medical terminology can be quite sophisticated, which presents the barrier. For instance, rather than stating the patient suffered blunt force trauma that resulted in a subdural hematoma, the doctor might just have to say that a serious head injury resulted in bleeding around the brain. And see, it's simpler to understand than you using all those medical jargons. Now, the doctor's duty in the court is to remain impartial and grounded in evidence, not to take sides. That's the first thing to note. Now, credibility in the workplace is crucial. A doctor must avoid hyperbole and be truthful about the boundaries of their expertise. Sometimes it is more professional to state, I cannot say with certainty, rather than making assumptions. Additionally, doctors collaborate with coroners, lawyers, forensic experts, and police investigators, particularly in complicated medical legal cases. Doctors and lawyers both have a significant role in bridging the gap between justice and medicine. Now, lastly, we'll look at the ethical dilemmas. Sorry, Ibrahim, please, can you mute yourself? Ibrahim, please mute yourself. Alright, so ethical dilemmas and challenges at the intersection of medicine and law. Now, these obligations of the doctor are crucial, but they are not always simple. When medicine and legal investigations collide, doctors have numerous difficulties. External pressure, sometimes as well, is a very significant obstacle. Now, families, law enforcement agencies, employers, powerful people, and even the media may put pressure on the doctor. And they may occasionally try to sway medical findings or make unethical requests for private information. Now, finding a balance between legal requirements and secrecy presents another difficulty to doctors. And although doctors are taught to preserve patient information, there are several circumstances in which disclosure is required by law. Now, emotional tension is another issue. And in this emotional tension, we understand that healthcare personnel may experience psychological effects from cases involving child abuse, sexual assault, traumatic injuries, and tragic accidents. Furthermore, we understand that even though we routinely deal with courtroom procedures and medical legal practice, in actual clinical work, many doctors have little formal training in these areas. Therefore, the overlap between medicine and law can be emotionally and professionally taxing. So, in conclusion, the doctor's responsibility goes well beyond only diagnosing and treating the patients. Doctors play a variety of roles at the interplay of medicine and law, including those of caregivers, documentations, guardians of vulnerable people, expert witnesses, and handling of moral challenges. Now, by way of conclusion, I say that the doctors are guardian of truth. And then medicine heals body. When it meets the law, it can heal justice itself. The key take home in our discussion today is that number one, that your documentation is a legal evidence. So you need to treat it with that gravity. Second, you need to be informed about pattern recognition in trauma, because this can save lives and secure justice. Thirdly, abuse identification is a clinical skill with profound legal consequences. Fourth, courtroom testimony is a professional skill that can be learned. And then finally, challenges are real, but so is duty and the honor. So in the end, protection of human life, dignity, and society is a shared goal of both medicine and law. Thank you very much for listening.
Thank you so much, Dr. Ozemena. Thank you so much for this impactful learning. Thank you so much. Thank you so much. I really appreciate. I'll be calling over to our second speaker, Barrister Moses Agu, to take over the floor. Barrister Moses. Is Barrister Moses around? I feel like... Okay.
Okay, good evening, everyone. I don't know if I can be heard. Please, can you confirm if I can be heard?
Yes, you can be heard, Barrister.
Thank you so much. Good evening once again. Well, I've been paying keen attention to the first Dr. Ozemena. It was quite an insightful one and educative one. Like I've been in my notice, it showed a lot of key points that I noted from it, impactful discussion. Like, thank you so much. I want to thank the organizers of today's event, for inviting me to speak on pertinent and core issues affecting anyone that uses the medical space and the legal space as well. I also once again want to, acknowledge Dr. Ozemena, Dr. Odio. Forgive me if I do not get the pronunciation very well, Dr. Isiako, and my learned colleague, Kosimba, the president of Institute Medical Student Association and the president of Law Student Association, Institute, the convener, Ambassador Collins. Thank you once again for this wonderful opportunity to speak to great minds and great Nigerians. And the audience, I do not take you guys for granted. Thank you for being part of the conversation. At the moment, I'm getting requests, messages, my DM, people wanting to join the call. But unfortunately, the call has reached its limit. So the convener, next time I advise that you look at platforms such as Zoom or Google Team. I think it has a larger audience than Google Meet.
Okay. I tried using Google Zoom, but I noticed that it's also the same capacity as Google Meeting as well. So I decided to go with Google Meeting. I thought it's Google Meeting because I asked my chiefs that have used Google Meeting. He said it contains more people, so I thought maybe it's going to expand more to reach more persons. But then in our season 2, it will be much better. Thank you so much.
Yes, no problem.
Okay.
Yes, no problem.
Yeah.
Okay. Once again, the convener has asked me to speak on the following issues as it concerns today's discourse: intersection of medicine and law, fundamental rights of patients under the law, legal consequences of medical negligence and misconduct, procedures for suing medical institutions, regulations of hospitals and healthcare practitioners, and the medical licensing and disabled bodies in Nigeria. There are quite a number, but the time allotted to me will not be enough for the purposes of the topics that I'm to handle, but I will try as much as possible to pinpoint the areas that are relevant to you and I, the areas that will be impactful. So I'll be fast because I do have another meeting to join. In fact, I've already received a call, but I'll try as much as possible to be fast. So while Dr. Ozemena was talking, I jotted some things such as documentation as important aspect of medical practice. He said that every practicing physician is a potential witness. He also said that medical practitioners interpret trauma, generate evidence, and influence the legal system, among many other things that I jotted. When he started, Dr. Semena said that doctors or medical practitioners can be seen as a legal actor, one way or the other, and he tried to break it down to explain what he meant by that. Respectfully, I disagree with that. However, I believe that each field, they have the role they play in society, and we'll try as much as possible, to link and see the role of lawyers in this medical law. We call it medical law, basically. So, for one to be a patient, it is important that you must first of all be a human being. So I said I do not think that an animal for scientific purposes is regarded as a patient. So and the surgical body, human bodies for practicals, I believe, are not regarded as a patient as well. So it comes to bear therefore that only a human being that has fundamental rights, capable of being enforced, are patient.
Now, why do I say so? When you go further, you see that it is only a person that is alive that can enforce his right. A dead man does not have a right to enforce. A dead man does not have a right to enforce. So, and for that person to be alive, the medical practitioner has a role to play, that is to ensure that the person get the best medical practice that can be given, that is expected of a medical practitioner in that capacity. So when we talk about fundamental rights, there are key distinctions between fundamental rights and human rights. So for the purposes of today's discussion, we say that human rights are those inalienable. They are those inherent rights ascribed to a person because he's a human being. Inalienable, inherent. This is a right that comes with them as a result of their birth. So it's either you're born a man or you're born a woman. Although people may have a dissenting view, some say that the other genders existing, but it is important to know that either one is born a man or is born a woman. And when you are born, there are these rights that are natural, that inures to a person. So those rights, we call them human rights. So these rights are regarded as a wide continuum of values or capabilities thought to enhance a human or protect a human interest, irrespective of the person's gender, the person's race, the person's religion or origin. Every human being has an inalienable right as a result of their birth. So I'm going to try to distinguish between human rights and fundamental rights in just one word. Human rights, like I said, they are those natural rights, inalienable, that pertain to a human because he is a human being. Fundamental rights, in the other way, they are those rights that are guaranteed by the law of a particular jurisdiction, a particular country. So, not all human rights are fundamental rights in Nigeria. Not all. So, when we say fundamental, let me repeat, fundamental rights are those rights that are domesticated, recognized, and guaranteed by the ground norm of a country, that is the constitution of a country. So that's why I say a particular jurisdiction. So they are fundamental because the law of that country has recognized those rights. That is why we say they are fundamental rights. But they are human rights because the right is ascribed to you because you are a human and you are born with it. So with talking about human rights, it can be traced back to the Universal Declaration of Human Rights in 1945. It outlines about 25 human rights, such as right to life, right to freedom of thought, right to freedom of conscience and religion, freedom from slavery and inhuman treatment, freedom of speech, freedom of movement, freedom of association, among many other rights. So these are the rights categorized as human rights by the Universal Declaration of Human Rights in 1945 under the UN auspices. So, but it is important to understand that in Nigeria, our constitution, the Constitution of the Federal Republic of Nigeria in 1999 as amended, recognized some rights. Upon the recognition by the Constitution, that is, the rights being in our Constitution, it becomes fundamental. And these rights are visibly domesticated or enshrined in Chapter 4 of the 1999 Constitution, starting from Section 33 down to 44 of the Constitution as amended. These rights, like I said before, right to life, right to privacy of human person, right to dignity of human person, freedom of religion, freedom of speech, movement. So these are fundamental rights that are guaranteed to every person in Nigeria. And in this context, we are looking at the patient. So I'm going to explain the fundamental right of a patient in this manner. Right to life and medical care. Like I stated before, that it is only a person that is alive that has a right, that can enforce this right. When you are dead, you cannot enforce right. The only thing that could be done is if the dependence of the disease enforces the right. That is, if the right is the one that the dependence of the disease can enforce. So, right to life and emergency. When Dr. Ozemina was talking about, he made mention of the gunshot situation, that when a patient is brought to the hospitals, usually before now, hospitals we insist that the patient produce a police report before treatment. And like he rightly said, that has caused a lot. So the National Health Act 2014 has abolished that, because if the person you want to treat is not alive, he's no longer a patient. You can't treat someone that is dead. It is important. So, right to life, I say to be, it's at the forefront of all the fundamental rights. And this right is guaranteed by the Constitution. Now, there are other rights in the Constitution which I did not mention here. They are found in Chapter 2, starting from Section 13 of the Constitution, down to 20 something. Those rights are not enforceable. We say they are not justiciable. But the rights in Chapter 4 of the Constitution, such as right to life, right to freedom of thought, conscience, and religion, freedom of expression, freedom of movement, freedom of association, right to own properties, they are guaranteed, and you can go to court to enforce this right. But the ones in Chapter 2, I believe those students that have done this, they will understand that the ones in Chapter 2, they are not justiciable, they are not enforceable per se, but there are instances where they can be made enforceable. That is why it is important that as a medical practitioner now, you have you make a friend a lawyer or a law student, so that should any case arise, you seek their medical advice. Now, right to life and emergency care, like as I put it in this discourse, I said earlier that life is important. So the right to life is the fulcrum of all other rights. So all other rights draws inspiration from right to life. And therefore I say it is only a living that can enforce his right. If a person is dead, he cannot enforce any other rights, such as freedom of expression. If you are dead, you cannot enforce freedom of expression. So this is what made me to go further to look at what the provision of the National Health Act 2014, Section 20 of the Act, provide that medical personnel or establishments shall not refuse emergency medical treatment for any reason whatsoever. So for the fact that the patient, someone is brought to your hospital, and from what Dr. Semina said, documentation and everything, and you as a medical practitioner, you've looked, you've seen, and you've asked questions, you've asked the patient question, and they say that it's a gunshot, armed robbers or this, then you start demanding for a medical report. The National Health Act of 2014 has totally criminalized that. Any doctor that under his care, a patient dies arising from gunshots, and the patient has been brought to the hospital, and the hospital did not take adequate measure to provide the necessary, medical services needed, the hospital will be liable to lawsuit. The hospital will be liable to lawsuit. Now, we encourage Nigerians, we lawyers, we encourage Nigerians, they should seek redress. I was discussing with a friend, I told him that, we conducted a survey, and the survey turns out that 7 in every 10 Nigerians have had a reason to go to court. 7 in every 10 Nigerians, they've had a reason to go to court. Out of these 7, people that will eventually go to court, there are 3. Then the remaining 4 take it to God, that to Babalawo, to whatever they believe in, they take it to God, they leave it to God. It shouldn't be so. Our society has evolved. It has evolved. So the National Health Act has criminalized that, because if the patient is not alive upon getting the police report, I'm not sure you will be able to give him any other care at that point in time. So that is why it is important that if a patient of gunshot comes to a medical facility and needs immediate treatment, the medical facility and the practitioners on ground should ensure that the patient gets the treatment. Thereafter, they could, request for a medical report. I know that most hospitals do this to avoid subsequent consequences, but the act is the law. The law dictates what happened. That is why medical facilities, medical institutions, they have legal department. That is the lawyer does work. So, furthermore, I say so that even prisoners are entitled to care, because they have to be allowed to face their trials. If a person is not alive, the person cannot face his trial in court. So we have right to privacy.
Barrister, please a minute. Sorry, please a minute. Samuel, can you please off your camera? Thank you so much. Samuel, please off your camera. Thank you. Okay.
Yeah. All right. Now, right to privacy of human person and confidentiality. This is where, when Dr. Zomina was talking, particularly as regards to documentation, I paid attention very well, because there's a relationship between documentation and right to privacy. And right to privacy is guaranteed in Section 37 of the Nigerian Constitution. Now, patients, not only patients, Nigerians are entitled to the confidentiality of their personal information and their medical records, their personal health data, their treatment details cannot just be disclosed to a third party. So when you ask the patient, how are you feeling, this, and the patient says this, and you put, you pen it down, you document it as stated by Dr. Ozemina, those codes is between you and the patient, although that is not conclusive. There are exceptions to the general rule, and I'm going to state a few. So the exception to is when the court, for instance, demands for the medical record. If the police brings a letter asking that the hospital should give them medical record of Mr. A, the hospital have no right to release medical record to the police or to EFCC or to any other law enforcement agency. What the hospital would do is to respond to the police, telling them they are not the court. It is the court that has the power to grant an order compelling a medical practitioner or professional, as the case may be, to release health record of the patient. So if they bring their letter asking, they need a court order, they are not the court. Section 6 of the Constitution of Nigeria has empowered the court to interpret the law, the Constitution, and so many other laws that we have in Nigeria. So we need to be conscious of the fact that in an attempt to please these law enforcement officers or institutions, we will be breaching the Constitution. Should I be the one that the police officer meets a hospital that have my medical details and they quickly release it to them? I'm going to sue the hospital. So what I'm saying is that it is the courts that have the jurisdiction, the authority, and the power to grant an order mandating the medical practitioner or medical institution to release medical record. So what I am saying in essence is that medical data, medical records of every patient should be protected. And not only about being protected, it also talks about the image of the doctor involved, the image of the hospital. Imagine, I'm going to use Collins now and the LOSA president. Imagine Dr. Collins and the LOSA president. LOSA president is a patient of Dr. Collins, and he has disclosed to Dr. Collins in the course of their consultation that he's having one ailment or the other. Then Dr. Collins, maybe he ran into LOSA president's wife. Perhaps he's married, but he's not yet married now. He ran into him and he started saying, "Oh, do you know that your husband is impotent? Do you know that your husband have HIV? You know, come on." You see, he has as well breached that right to privacy of the LOSA president. So doctors, even the professional, the code of conduct of medical practitioners expect them to keep those records, those information confidential. So I'm going to talk about that confidentiality. So they're supposed to keep it confidential. So it is unethical for a medical practitioner to go about telling people or a third party the diagnosis of a patient. That's also, we bring a lawsuit to the medical institution, to the medical practitioner here for breach of privacy. So confidentiality is to the effect that secret information of the patient is protected by the medical professional, except as may be required by the law. So I say for that, should there be a breach to this, the patient can seek redress in court. The other right I'm going to talk about, before I quickly go to the other topic time, is the right to dignity of human person and informed consent. Right to dignity of human person and informed consent. It is very, very important. Very, very important. Every human being should be respected, should be accorded their due respect, irrespective of where they are from. Should be treated professionally. So, the Constitution guarantees this right. Now, there is what they call consent. When Dr. Semina was talking about documentation, a patient has approached the hospital for a particular treatment. After the hospital have finished taking data, names, the image and everything, the patient is supposed to sign. Should there be a reason for a surgery to be performed on the patient is supposed to sign. Upon the patient pending his or her signature on the document, consent has been given. That is on that part. But I'm going to explain the difference between giving consent and giving informed consent. They are not the same thing. They are not the same thing. So, I'm going to use two practical cases, that many of us are aware of. The case of Ikekwe Madu was tried in the UK. And I believe that we have the facts of the case. But what I want to point out is that Ikekwe Madu thought that she needed a kidney transplant. The young man in question that is the donor, right? The donor, he was informed that we need your kidney. He agreed. Now, there's a difference between agreeing orally. It needs to be in writing. Whatsoever a patient is saying, it should be in writing, because in court, there's who can rule of hearsay. Attribution what the say cannot be true. How can you prove and oral this thing? So, now in the Ikekwe Madu's case, the guy agreed. Upon getting to the UK, when a nurse into him further. Now, informed consent is when you have explained to the patient that this surgery is needed, but consequence upon after the surgery, that these are the side effects. So you give the patient all the details, the consequences of the surgery and the effect thereafter. So you are telling him now, please think within yourself, not just giving consent, I've agreed. Now, should this happen, should this second kidney fail, you are going to die, or you need a transplant. So now you make all the facts clear to the patient. So we say it is informed because you have let all the cards on the table. You have explained all the details, all the side effects, all the medication the patient will need. At that point in time, it will not be left to the patient to now agree in writing. Upon agreeing, the patient has given what we call an informed consent, because he has been informed of the consequences of the surgery pre and post. So another case I'm going to use is the case decided by the Supreme Court of Nigeria. The case is the case of the Medical and Dental Practitioner Disciplinary Tribunal versus Okonkwo, Dr. John E.N. Okonkwo. So, this is a case, it pertains to consent. In that case, one Mrs. Martha Okore, a patient. So her husband and Dr. John Okonkwo himself, the woman, the husband, and Dr. John Okonkwo himself, all of them belong to the Jehovah's Witnesses set. I am sorry if you're a member of Jehovah's Witnesses, but this is what it is. So they are members of Jehovah's Witnesses, and that they believe that blood transfusion is contrary to God's injunction. Although I read somewhere in the journal that they have relaxed this position. So anyone that in Jehovah's Witnesses can confirm that. But this is the case, among other cases that we have, where the court, has made a decision regarding to consent. So in that case, the patient, a 39 years old woman, she had a delivery, at the hospital of Dr. Okonkwo, and after the delivery, there were some complications, that arise, and she needed the blood to keep her alive. She needed a blood transfusion to keep her alive. So the husband and the woman refused the blood transfusion on the basis of the doctrine of their church. So Dr. Okonkwo, also being a member of Jehovah's Witness, said, okay, since you guys don't want to agree to this treatment, excuse me, let me just take a sip of water. Alright, so Dr. Okonkwo said, since you guys did not agree to this treatment, good and fine, Dr. Okonkwo discharged them. She discharged them, and upon discharging them, he wrote something. He said the medical directive / release. In the card, the woman, he also acknowledged or put in that card, in what he wrote, that the woman refused blood transfusion on the basis of her religion. That this is what the woman said. So Dr. Okonkwo, upon discharging them, the husband, they signed so many other documents refusing the transfusion, and she now went to another hospital. So getting to that hospital, on getting to the hospital, the hospital told them that we cannot perform this operation, we cannot do this surgery, we cannot operate on this woman without blood being transfused. And they said, the husband and the wife said that they don't need blood transfusion, that they signed another document saying that the hospital should go right ahead and perform the surgery needed without blood transfusion. Then the doctor said, are you aware that this might be the probable consequence of we performing this surgery? That the probable consequence is woman died. They agreed. Well, the doctor in that Canadian hospital, the hospital they went to, performed the surgery. In fact, in the course of the surgery, the woman died. She died, right? And the Medical and Dental Practitioners Disciplinary Committee set up a panel after the investigation. Dr. Okonkwo was tried, for not rendering giving a professional services as demanded by the Code of Professional Ethics, Code of Medical Ethics, and the Code of the Profession. And of course, like I said, Dr. Kongwo engaged his lawyer, and the case were argued based on the evidences that were presented. Because, like Dr. Zumina stated, documentation is as an important aspect of medical practice, and it constitutes evidence. So if he, assuming they did not document it, there will be a problem. But everything from the first hospital down to the second hospital that this man was treated was duly documented. At the Supreme Court, I'm trying to round up, from this, the Supreme Court held that what the doctor did, the doctor that discharged them, he did it based on the fact that, let me read what the Supreme Court said. So the respondent proceeded to treat the patient in accordance with the directive that there should not be blood transfusion, and the patient died. So the dental and medical practitioner tribunal, charged them to court on 2 counts of negligence and acting contrary to his oath as a medical practitioner, and thereby conducted himself infamously in a professional respect, contrary to the Medical and Dental Practitioner Disciplinary Act. The tribunal, that is the Medical and Dental Practitioner Tribunal, found the respondent, that is Dr. Kongwo, found him guilty of 2 counts, and they suspended him from practice. And upon this body finding guilty, upon when they established the fact, they could make a case against the respondent, such as this doctor now, the person will be suspended. The first thing they do, that is the Medical and Dental Practitioners Tribunal, the first thing they do is to suspend the medical professional. That is, in this case, they suspended the doctor, and the doctor went to court. The respondent appealed to the Court of Appeal. The Court of Appeal allowed the appeal. Then the Medical and Dental Practitioner Disciplinary Tribunal thereafter appealed further to the Supreme Court, because the Court of Appeal said that what the man did was in alignment with what this patient asked him to do. So he performed according to the consent they gave to him, not just the consent, the informed consent that they gave. So the Medical and Dental Practitioner Disciplinary Tribunal appealed further to the Supreme Court. The Supreme Court dismissed the appeal of the Medical and Dental Practitioner Disciplinary Tribunal in the following words. Ayology, he said, the patient's constitutional right to object to medical treatment, or particularly, as in this case, to blood transfusion, on religious ground, is founded on fundamental right protected by the Constitution of Nigeria. That is right to freedom of religion, conscience, and thought. So the Supreme Court is saying that the patient, she has a right to refuse treatment too, and this right is anchored upon the fact that it is protected by the Constitution, which is her right to freedom of religion, conscience, and thought. Right? That is what the Supreme Court says. Then the right to privacy, the court further said the right to privacy implies that the right to protect one's thoughts, protect one's thoughts, secrecy, and everything. So what the court is saying in essence is that the doctor acted in line with the law. In fact, Honorable Justice Waifo JSE of the blessed memory added that I am completely satisfied that under normal circumstances, no medical doctor can forcibly proceed to apply treatment to a patient of full age and sane faculty without the patient's consent, particularly if that treatment is of a radical nature, such as surgery or blood transfusion. So what my Lord Justices of the Supreme Court are talking about is that you, as a medical doctor, you cannot go and conduct a surgery when the patient in question does not agree. Not just agreeing, it's not giving his consent. So, and what the doctors at the Okoko hospital did, by not performing the surgery and the woman dying subsequently, they did it in line with the directive, in line with, the consent given, by the patient and her husband. So the court subsequently dismissed the case of the Medical and Dental Practitioner Disciplinary Tribunal, and also reinstated the doctor with damages, among many other things. So this is to tell you that this consent we are talking about is very, very important. It's very, very important. Any doctor that goes contrary to that, I'm sure that he will lose his or her medical license. Another case that is very important, this case is a sad one. COP versus the case of COP versus, I'm trying to recall the title of the case, but this case is about, it's also talking about blood transfusion, where the child is a minor. Because in giving consent, when it has to do with a child, the consent of the guardian will be sought. So that is either the parent or the person that the child or the minor is living with. So in this case, I want to bring down the title of the case is not coming, but the fact of the case is that a minor was brought to a certain hospital by the parent. The hospital told the parent that we cannot do anything for this child unless blood is transfused to the child. So that the child needed blood transfusion. The father and the mother of the child, they disagreed. Our church doctrine say that there should not be blood transfusion and everything. Well, what the doctor did in that case, interestingly, the doctor wrote to the commissioner of police seeking consent from the commissioner of police that CEO, this is what is involved. Should the hospital not perform this surgery, the child will die. And the parents of the child, since that they do not want to take the responsibility of ensuring that this child lives, so the commissioner of police also seek a legal advice from the Ministry of Justice, Office of the Attorney General. The Attorney General, of course, they should go right ahead and approve the consent. The Commissioner of Police approved it. The hospital subsequently operated on the minor, on the child, transferred blood on the child, and saved the life of the child. After saving the life of the child, surprisingly, the parents of the child, they sued. They went to court on the basis that the hospital and the doctor and even the commissioner of police, they have violated their right to freedom of religion, conscience, and thought. That their consent we are not giving. Yeah, it is interesting to note that parents, guardians that are supposed to protect and ensure that this child lives, after the child has been saved, went to court. But in the wisdom of the Supreme Court said that the doctor acted within his professional competence and acted in line with the law. That should it be that the doctor went ahead to perform the surgery or the transfusion as a result of the parent denying without seeking consent of the commissioner of police, that would be a different ballgame. But the doctor, having sought a legal advice, sought a consent, went to the extent of getting consent from the commissioner of police. So the court held that the doctor, in fact, the first duty of a doctor is to save life, that the doctor maintained that, I think you guys call it Socratic rule of saving life. So it is important that if you as a doctor, when you encounter challenges, issues like this, you do not act on your own whims and caprices. You ensure you seek legal advice. That's why it is important, once again, to have a lawyer beside you. Have a lawyer as a friend. Have a lawyer. When anything arises, if issue arises like this, tell them you hear from my lawyer. All right. Okay. Quickly, we'll talk about fundamental rights. Then I'm going to talk about legal consequences of medical negligence, medical licensing, and discipline. I'm going to sum them together so that the next speaker can talk. It is important to state that when we talk about medical licensing and disciplinary bodies in Nigeria, under the relevant act, we have the Medical and Dental Council of Nigeria. The Medical and Dental Council of Nigeria is a statutory body established by an act of the Parliament, charged with the responsibility, such as investigation of misconduct by medical professionals, to discipline errant medical professionals, to even licensed doctors. That is why before you become a medical doctor, you will be inducted. So this council are responsible for induction. This council also prescribe quota that There are different councils. So I know they have for nursing, nursing and midwifery council of Nigeria. So we have for even the pharmaceutical council also. So all these bodies regulate the medical profession. Because when we talk about the medical profession, we're not talking about those in the practicing medicine. We're talking about those in the nursing profession too, those in the pharmaceutical profession, even the med lab scientists and all whatnot. So it is important to state that these bodies collectively and discharge their duty. And it is important to state too that the Federal Ministry of Health, state ministries of health also have responsibilities to discharge in licensing of hospital. And for a hospital to operate in Nigeria, the hospital must be registered under the extant law, which is the Companies and Allied Matters Act. Is it registered as a private company limited by guarantee? A private company limited by shades of public company. Sorry about that. So it is important that if you intend to own your own hospital, you should seek legal advice from a legal practitioner. I want to say this case concerning this licensing of a thing. There is a case I followed. I followed that case 2023. It came in 2023, and the judgment was given last year. It is a case of a plastic surgeon in Lagos, Dr. Anolu Olua, something like that. Case. The doctor performed the surgery, what we call the butcher surgery. Unfortunately, the patient died. That is all this BBL, Brazilian butt enlargement. So the patient died. But before the patient died, the patient was taken to Lagos University Teaching Hospital. I think Lasso Teaching Hospital, and the hospital there found that the medical doctor, that is the surgeon that did the BBL, one, did not follow the guidelines. Two, upon further investigation, is not a registered member of their association. Three, does not have a license in Nigeria to perform such kind of surgery. So, upon the death of before the death of the patient, that was the deceased, his younger sister wrote to the FCCPC, the Federal Competition and Consumer Protection Commission, because people have been complaining about the hospital. Now, in 2018, the National Assembly enacted the law of Federal Consumer Protection. It protects the rights of consumers. So FCCPC was trying to investigate this hospital. They invited the hospital for, investigation and every other thing. The hospital refused to appear. So consequently, upon the death of the patient, the FCCPC sued. They went to court. The Lagos State Teaching Hospital doctors from there came and testified that the doctor was professionally negligent and the doctor does not have license to practice plastic surgery in Nigeria. So it is important that if you are interested in any of these surgeries in Nigeria, you should first of all do your due diligence by ensuring that doctor first of all passed through the 4 walls of the university, did all the things necessary and has the license to practice that particular field of medicine, because I know that medicine is very, very broad. So someone cannot just wake up tomorrow and say that he's a dentist or he's a neurosurgeon. All those things, that is not how it works. There are processes and everybody is supposed to follow the process. I'm going to end with this. Medical negligence. I'm going to rush it because there's no time. Like I said, I have another engagement tonight. So medical negligence basically occurs when a healthcare provider fails to provide the standard of care a reasonable, competent professional in that same field will provide under similar circumstances. Nobody's saying that as a doctor, as a gynecologist, that you should go above board. No, but they are saying that you should provide that standard of care that a reasonable, competent professional in that yourself field will provide. So when you do not provide this standard as is required of you, it becomes medical negligence. So it is not simply bad outcome or successful treatment. No, you must provide the standard of care. So in Nigeria, medical negligence follows what they call the Bolam principle, which seeks whether the medical practitioner acted in a manner that will be accepted as proper by responsible body of medical professionals in Nigeria. And you know, when issues like this comes up, issues involving medical negligence, I want to bring the case of Chimamanda. We are all of us follow that case. I don't know how many of you are following it, but I'm still following the case because the case is still ongoing. The case of Chimamanda, you see something care hospital in Lagos. Chimamanda they alleged that the hospital did not take standard care. In fact, they were professionally negligent in the handle of their child, which subsequently led to the death of the child. As I'm speaking with you, the Medical and Dental Practitioner Council, through their tribunal, has suspended the doctors that were involved. That is to tell you that you as a medical practitioner or professional, you are not all and all. There are people that you are answerable to. Upon investigation by this committee, because for you to establish medical negligence, another doctor had to come and look at what, follow it step by step, and say truly this is what he ought to have done. So upon discovery of that, the doctors that were involved in Chimamanda's son's case were immediately suspended. As I'm speaking with you, Chimamanda is seeking close to 3 billion in damages for medical negligence. So to establish medical negligence, I'm rushing now. To establish medical negligence,
Barrister, please a minute. I sent you a message on this. I sent you a message on this group chat, on this Google meeting.
Let me check that.
Okay.
Okay.
Yes.
Okay. Thank you so much for that. Thank you so much for bringing it to my attention. So the last thing I'm going to say before, like he said, now he's pointed out to me that I've exceeded my time, and the last thing I'm going to say, I'm going to conclude this by saying that to prove medical negligence, I'm going to say there are 4 things that need to be established. 4 essential elements. First, duty of care, that the medical practitioner owed a legal duty to provide competent care. So, and where for competent care to emerge, there must be a doctor-patient relationship. Second duty is that the medical practitioner failed to provide that standard of care expected of a reasonable, competent professional in that field. Not just that you have duty of care, that you fail to provide that standard of care expected of you. The third is causation. That's as a result of the failure of the medical doctor to provide the reasonable and standard care needed that such breach occurred. Like in Chimamanda's case, as a result of them not doing what they're supposed to do, the death of the child occurred. And thirdly, which is the most difficult to establish, damage is that upon from the causation and the death, that this is the damage suffered damage, the quantum of damages that so, and these damages could come in terms of money, monetary forms, and suspension of license, sending the doctor to jail, like in the case of Anolu Poluwa in Lagos, the doctor that involved in the butchered plastic surgery was sentenced to 1 year's imprisonment. With this, I have come to the conclusion of my own aspect of this medicine and law intersection. Thank you so much for this opportunity once again.
Thank you.
Back to you, Mr. Collins.
Thank you so much, Barrister Moses. I really appreciate it. Thank you so much for this impactful session. Thank you so much for your time. Thank you so much. I believe we all learned a lot. And there's still a lot more that you wanted to say, but because of time. Okay. Over to you, Dr. Rosemary, please. The floor is yours.
Oh, okay. Thank you very much. I hope that you can hear me clearly.
Yes, we can.
Okay. Good evening, everyone. Standing the already established protocol. It's an honor to be here. I've learned so much, just hearing from these 2 great speakers, and the last session was particularly enlightening because, there's an intersection between like what he's saying and then what I'm going to say as well. So I like that he has already laid the groundwork for me, and I hope that I carry everyone along and that we learn as much as we can in this session. Okay, so permit me to share my screen. I actually prepared like a PowerPoint. It's going to be it's going to be brief. It's going to be a brief session. It's even going to be more brief as I've gotten help from Barrister Moses Agu. And I want to thank Barrister Moses Agu especially, for opening our eyes, because it's good to have somebody in there, like in the system, knowing how the thing works, being able to highlight things and telling us, you should have a lawyer because you can think that you're acting in the correct way, but then when you check it according to the law, you find out that maybe you missed something. So I'm going to proceed now to share my screen and then we'll start in earnest. Okay, can you see my screen, everyone? Anyone?
Ma. Yes, ma.
Okay, you cannot see it. Can you see? Can you see my screen?
Yes, we can see. Yes, ma.
Thank you very much. So, my topic is medical ethics of I am so from everything that we've been hearing, we realize that medicine and medical practice is not just about diagnosing and treating people. You have to be able to make some critical decisions, and you have responsibilities also. We are supposed to respect patients' rights. We're also expected to provide competent care, maintain trust. There's a lot that is expected of us. We're supposed to also act in accordance with the professional standards and according to the law as well. And you're wondering, how can we juggle and balance all of this? I hope that we'll be able to find out together how we can do that. So before I dive into it, this is my table of contents. I've been asked to emphasize on informed consent in medical practice. I feel like it's going to be fast because we've already heard like a great deal about it, and what I'll just be doing is reiterating the points that Barrister Moses has said to us. Then I will also emphasize on doctor-patient confidentiality, like he also said, and legal exceptions, and then ethical decision making during treatment, the duty of care and responsibility and professional responsibility, and then medical negligence from a clinical perspective. So before I start, I would like to talk about these 4 major ethical principles. Okay, so I think that we've all been discussing. I don't know if we know what ethics is. I feel like we would all know what ethics is, but just to reiterate that ethics is like a thing that guides us, like a set of moral principles that guide what we should do at this time and at this time in this situation and in this situation. So it's like a code of conduct per se. And we have principles and ethics that we go by, that we always respect. And those 4 core principles that I want people to always know and go away with include autonomy. Autonomy means self-rule. It means like they have been emphasizing you have to respect patients' choices. Like the patients are the chiefs. They are the number one in decision making. Everything that we are doing is for the patient, because at the end of the day, they are the consumers, and they said that the consumer is always right. So autonomy is very important. It's like one of the key major ethical principles, and it's important for me to note that after listening everything, I'll tell you that autonomy overrides every other thing in the grand scheme of things. So let's go on to beneficence. Beneficence is where they tell us, that you have to act always in the best interest of the patient. You have to be willing to do good to the patient. From the word like beneficence, you're doing good, you're loving, you're performing charity. Everything that you're doing is towards the patient's best interest. And then non-maleficence, like we've always been hearing, that you should do no harm. First, do no harm. If you're like a medical student or you're medically inclined, that is one of the first things that you say, like in your Socrates oath and all of that. Then the 4th thing is justice, which ensures that every patient is treated equally and that they receive like what they are owed, like they get fair and just treatment, what they are supposed to receive in every given situation. So being armed with these 4 principles, I want you to keep in mind always that autonomy is always going to overrule beneficence. In the sense that no matter how well you want to act in patient's best interest, no matter how much good you have, how much love you have for this patient, I don't want to see this patient suffer, I want to take away this patient's pain. If the patient does not agree, you cannot do anything. So I want you to be armed with this knowledge. I feel like it's also one of the things that previous speaker was emphasizing on autonomy. And then having said that, I will now go on to informed consent, because informed consent also is the major ethical principle in. Okay, can you still see my screen? Because I feel like I don't know what happened, but I saw that someone was commenting and
No, we cannot see your screen.
No, we cannot see your screen. Can you just try to share your screen too?
Okay, I will. Okay. So sorry about that interruption. Okay. Okay. I hope you can see it now. Can you see my screen now?
Yes, we can see it.
Very good. So now let's head on to informed consent. I said it's going to be light work now because of the amount of work that my person that spoke before me put into it. So I'll just be breezing through it and telling us like some important things, and also adding to a few things that maybe he might have not disclosed. So now I was telling us that the ethical principle in informed consent, the reason why informed consent is even there is because we want to respect patients' autonomy, which is the patient's right to make decisions concerning their own body. Do you understand? So now, for you to make an informed consent, first of all, there are things that must be there. There are elements that you must have for you to be able to make an informed consent. So now you have to make sure that the patient will receive the information you want to give them concerning whatever it is that you want to do, and that information, the patient understood it. It must be understandable. You cannot, and it's very important for you to not use medical jargon, especially like in settings where you are talking to people that might not really understand what you're trying to say if you're using highfalutin words. So you have to come down to the patient's level, because understanding is a very, very key element. And then the patient must be able to make decisions. Like the patient must be competent, they must understand and then use that information they have given them to decide what it is that they want to do. And this is very important because there are some people that are not competent enough to make decisions. Like in cases of mentally unstable patients, those are scenarios where you can see that it's not an informed consent in the grand scheme of things. And then the decision must be voluntary. This is very important. You don't force a patient to do anything, no coercion, none of that. So these are the elements that are supposed to be there for you to say that you're giving an informed consent. And then if you want to now give the information, you have to tell the patient about the diagnosis and the treatment that you want to do, the benefits of the treatment in understandable language. Very important to not use medical jargon in any way, and tell the patient of the risks from the procedure, whatever, and alternatives that patients could also of refusing treatment. Noting that the most important thing here is the patient's autonomy, the patient being able to choose what they want. And I also want to talk about how, I almost called him our brother, forgive me, I'm going to call him my chief, the person that spoke before me. He was talking about how we need to have a signed consent. Normally, they teach us in medicine that there are 2 types of consent. It can be oral, it can be written. But you have now seen that, according to, I cannot remember the exact word that he used, but I think he said something about the law of hearsay. You have now seen that some things are inadmissible in court, so you have to be armed to handle if you're going in for anything. The written oral consent is fine, good, you've gotten that. But then it's also important to arm yourself with documentation. Like the person that spoke before that, my chief, Dr. Ozemena said was emphasizing to us the importance of documentation. It's not something that you can do without in medical practice. In fact, starting my house job in Parkland was one of the first things that they told us about during our orientation, because you now see that it's very, very, very important that you document everything. So signed consent is very important, no matter what you are doing. And then remember that the goal of everything that you're doing is to make sure that you properly communicated to the patient what you want to do and that they have understood it, and then you now allow them to make the choice. So what you're taking away from informed consent is that you're trying to respect the patient's autonomy. So now there are some situations. I think I gave a scenario here where there's a teenage girl that arrived unconscious. She had a dangerous illegal abortion and then she needs immediate surgery. But she's unconscious and you cannot reach her parents. Remember that I said that this patient is a teenager and time is running out. You see that what can you do? I really love how the person that spoke before me talked about the fundamental human rights and how you cannot treat somebody that is dead, how somebody that is dead is not a patient. So, I was going to throw this question out in the open, but I feel like somehow you kind of already know what to do in the grasping of things, because we are now armed with the knowledge of what he said to us. So the reason why I give this scenario is just to highlight to us situations where informed consent can be difficult and almost even impossible to get, and what to do in those situations. Now, for instance, the first thing is in life-threatening conditions like emergency cases, like the one that he mentioned about gunshot wounds and those victims. You have to be able to do something for them. You don't start waiting for protocols and all of those things. Doctors are covered in these cases, but what you can do is that you have to inform all the departments that are involved to know if there's, like, for instance, in my institution, when I was doing my obstetrics and gynecology postings, we had a patient come in during when I was doing emergency postings, and she needed something to be done for her, and her mom was not coming forward with the consent. She wanted to confirm from their pastor whether or not to go on with the procedure. I think she had a ruptured ectopic, and what was going to be done to save her in that moment was to take her for an emergency exploratory laparotomy. Forgive me, my law counterpart. It's a procedure where you go in to explore, like you have to open up the abdomen so that you can find out where it's bleeding, because in an ectopic pregnancy that is ruptured, it means that the pregnancy is going somewhere else that is not in the womb, and that means it's not a good thing. And if you rupture, it can cause bleeding, and from bleeding the patient can go into shock and can even die. So it's an emergency condition. So what we needed to do was to do something for the patient. And you now see that in those kind of scenarios where the patient is unstable, obviously she was unconscious, she didn't know what was happening. Her mom, that we needed to give us, to talk to us and tell us something positive, was dragging her feet and was saying that she needs to talk to her pastor first. That her pastor says that her child is not supposed to have any surgery, that that she's covered with those kind of things. And you can just be very flabbergasted when you meet things like this. But now you now see that what can you do in these scenarios, and how can you? It's very good to keep a lawyer, have a lawyer's number, but then also remember that it's a life-threatening emergency scenario. So what we did was that we informed. We have a body here that they call CMOCA. We also informed our HOD and all the people that were supposed to be informed. We told them about these cases. I think the CMOC is like a program to provide funds and to help people that don't have so much money, so that we can be able to perform surgeries for them. So we now inform those people, and then we are now able to take the patients in, do the surgery, and save the patient. So you now see that in this case, with these life-threatening emergency cases and some things are happening, you have to act first to save the patient. So inform everybody, make sure that you covered your basis, tell your professional colleagues, people that you're supposed to get input from, inform our consultants and everybody that's supposed to be informed, inform them. And then also another scenario is people that are mentally incapacitated. You see that you cannot really say that you're giving them informed consent. So in these cases, you find people that are their relatives, or maybe people that I think they do this thing where like the law is saying that this person is their legal guardian or something like that, that they can make decisions for this person. So you go to those people to get consent. And then also for children and minors, people that are less than 18 years, you see that you cannot get informed consent from them. So like this lady now, and our senior teenager. So these children are minors. What they can do, if they are old enough, they can listen in, they can give an input when you're talking to them about whatever will happen to them. But at the end of the day, if you want to take the consent, it's going to be from their parents or their legal guardians, people that are involved. So that is it for informed consent. So now I'm going to go on to the second thing. The next thing I'm going to talk about is doctor-patient confidentiality and legal exceptions. So now my colleague he has also talked about this in-depthly. So what I will do is just going to be like a very fast summary so that we can move ahead. Now we already know what confidentiality is. It means that you have to safeguard every information that you get during your doctor-patient relationship. Like he said, it's not everything. In fact, you cannot be going around telling people other people's businesses. That is like a fundamental thing. You are a doctor or not, you're supposed to be able to mind your business. But as a doctor now, you now see that you have a responsibility to keep the information that people have given you, because it's not very easy. There are some very delicate and vulnerable information that you can only get from people because of the power and the position that you hold as a medical doctor. You can ask them very sensitive questions that they will not be willing to tell anybody, even their closest partners, their spouse, their friends, their family, but they're going to tell it to you. You see that there's a level of trust that is given to us by society and by God, because I don't know why they gave it to us, but we thank God they gave it to us. Don't mind me. But then it's important. This doctor-patient confidentiality is very important in medical practice. Why? Because it helps us to build trust. It also encourages honest disclosure. For you to be able to even help a patient, you have to truly know what is wrong with them down to the core. And if they know that they can confide in you and that whatever they say to you is not going to go anywhere else, then it will help them to tell you everything. And it will also help you in turn to make your diagnosis, to be able to properly manage them the way that they are supposed to be managed. And then it also helps to protect patients' privacy, because like very, very importantly, like our counterpart, our brother mentioned, he said that there's rights to, I'm sorry if I get this wrong, forgive me, but there's rights to privacy. I think there's that. So you see that it's very, very important that you protect patients' privacy. And then it also strengthens professional integrity. You know that whatever it is that anybody is saying to you, that if you tell them that you're not going to say it to anybody, that they will believe you, and like you're a person of your word, and people can trust more in our profession. So now you now see that there are exceptions, so where this confidentiality, this safeguarding information has to, you cannot keep this information. And these exceptions are, I listed it above. I think it was one of the things that he failed. I think he forgot, because he was talking about very, very important things. I don't know if you remember to mention the exceptions, like he said he would, but then the exceptions that you have to breach this confidentiality things, in situations, for instance, where the patient allows you to tell other people or to tell somebody about what is happening. For instance, they say, okay, you can tell my wife that I have this thing, or you can tell this person that I do this and do this, that kind of. So they permit you. So this is an exception where you can breach that doctor-patient confidentiality. Another one, okay, yes, he mentioned this actually. He mentioned it, forgive me. He talked about this. If the disclosure is required by law, he was talking about how if a police officer asks you to bring something, don't bring it, don't take it anywhere. You must make sure that they have a court order. So if the disclosure is required by law, the law is the principal thing that can make you disclose anything. It's not all these other institutions. So this is an exception. Then also, if there is the risk of harm to others, for instance, now let's say somebody tells you that they want to go and kill somebody, like let's say a mentally ill patient tells you that she has been thinking about killing her mother for a while now, and she thinks that she's going to do it. You see that this kind of thing you have to act, because if you don't act, for instance, now the mother might be killed, or even in some situations whereby some people that can be a lot, they are going through things and maybe they come down with all these communicable diseases, like for instance maybe HIV, and then they say that they are very angry that they came down with it, and they will not rest until like 48,000 other people have gotten this HIV. These things are things that you will not. This is a risk of what. So you not allow these things to slide. And then also importantly, communicable disease, like for instance, someone has Lassa fever, or all these things are people that don't want to be quarantined, and they say that they want to go back into the world. These are things that you have to talk about so that you can save more people. You are looking at the greater good. So these are the important things. So now, you have to be able. The thing you have to take away from this doctor-patient confidentiality is that you have to be able to balance this confidentiality with beneficence and public safety. That's what we're trying to emphasize here. You know that one of those core things in ethics is beneficence. So you always have to think about doing good to people, and then what is going to benefit people at large. So that is what you should keep at the back of your mind, okay? And as you are doing whatever you are doing, you should always keep a lawyer handy so that you don't cross any lines. Okay. So now let's
Dr.
continue.
Rosemary.
Now this is
Sorry, please, 1 minute. I sent a message.
okay.
Yes, please just take it. Not on this group chat. Okay.
Okay.
Yes. Thank you.
Okay. 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 Okay, thank you. Thank you very much. I'm going to be finishing very, very soon because I've had like a lot of help from Barrister Moses Ago. So let me continue quickly so that I can conclude. So as I was saying, you have to be able to balance confidentiality with beneficence. Now I was showing you this picture about patient autonomy and medical knowledge, and you will see from this picture that somehow this autonomy kind of like is winning in this picture. And this is just to emphasize what I've said to you before, that patient autonomy always overrules whatever it is that you want to do. Beneficence, normalization, justice, all of those things, autonomy prevails. So now let's go on to this very important thing: ethical decision making during treatment. And what this means is just, how can I choose what is the most right thing to do for my patients in any clinical situation, especially in difficult clinical